attorney Laura Anthony, founding partner of Legal & Compliance, a full-service corporate securities and business transactions law firm. Today is the final in a Lawcast series talking about cybersecurity, and in particular, in this part of the series, we have been reviewing Regulation Systems Compliance and Integrity, i.e. Regulation SCI, which was adopted by the SEC on November 3rd, 2015, to improve regulatory standards and processes related to technology in the securities industry. Over the past few Lawcasts, I've been going over the rules under Regulation SCI, and we'll finish this series with those rules. Rule 1001 requires that SCI entities establish written policies and procedures designed to ensure that the entity complies with the Securities Exchange Act and the rules and regulations under the Act, as well as that entity's own governing documents. The rule provides a non-exhaustive list of minimum elements that must be included in such compliance policies and procedures. These elements include: 1. Testing of all SCI entities and SCI systems and any changes to SCI systems prior to implementation. 2. A system of internal controls and procedures over SCI systems and any changes over SCI systems. 3. A plan for assessment of the functionality of SCI systems designed to detect system compliance issues, including by responsible SCI personnel and by personnel familiar with applicable provisions of the Act and the rules and regulations and the entity's own governing documents. And 4, a plan of coordination and communication between regulatory and other personnel of the SCI entity, including the people that are responsible for implementation and oversight of the processes regarding these SCI systems, designs, changes, testing, and controls, and the purpose being to detect and prevent system compliance issues. Rule 1002 contains the obligation with respect to SCI events, including corrective action, SEC notification, and public information dissemination. Under the rule, an SCI delineated person must take the required action upon reasonably confirming that an SCI event has occurred. As such, the SEC requires an SCI entity to have written policies and procedures that include the criteria for identifying responsible SCI personnel, i.e. who is responsible, the designation and documentation of responsible SCI personnel and how they are trained, and escalation procedures to quickly inform those responsible SCI personnel of potential SCI events. Such responsible SCI personnel mean for a particular SCI system or indirect SCI system impacted by an SCI event, such senior managers or management of the SCI entity having responsibility for that system and that person's designees. The rule contains in-depth and detailed discussion of corrective actions, notification requirements, and information dissemination requirements. In essence, the SEC must be immediately notified of all SCI events other than a de minimis event, although even de minimis events must be recorded, and there's particular record-keeping requirements and obligations that those must be included in all SCI reports. Until the SCI event is resolved, the SCI entity must keep the SEC regularly updated as to the progress of the investigation and resolution of the event, and must file a report with the SEC once the event is resolved. Subject to certain exceptions, the SCI entity must disseminate information to its members and participants regarding any and all SCI events. Rule 1003 contains requirements related to material system changes and SCI reviews. In particular, Rule 1003 requires quarterly reports to the SEC describing completed, ongoing, and planned material system changes and the security of indirect SCI systems. Rule 1003 also requires a minimum of an annual review of an SCI entity's compliance with Regulation SCI. Rule 1004 contains requirements related to business continuity and disaster recovery plan testing. As with notification requirements, an SCI entity must designate certain personnel to complete business continuity and disaster recovery plan testing. In particular, the SCI entity must designate those members or participants that the SCI entity reasonably determines are, taken as a whole, the minimum necessary for the maintenance of fair and orderly markets in the event of the activation of a plan. Such testing must be completed at least once every 12 months. The record-keeping and electronic filing requirements of Regulation SCI are laid out in Rules 1005 through 1007. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.